Welcome, everyone. We're just waiting a moment for some few people to trickle in a bit. Welcome, everyone, to our Startup Law 101 event hosted by Grid 110. Join us as we learn about everything you need to know and think about when you're starting your business on the legal side. My name is Michelle Heng. I'm the new event associate at Grid 110. Grid 110 is a nonprofit startup accelerator based in Los Angeles, providing access to resources, education, mentorship, and funding opportunities for underrepresented and overlooked startup and small business founders. If you are absolutely in love with this event, please be sure to follow our social accounts where we will announce all of our free events and workshops for our founders. We also record all of our events and post them on our YouTube channel. So make sure you subscribe for all your startup and small business content. This session will definitely be on there later this week. I have dropped some goodies in the chat so that you can be sure to follow us for more information. I am so excited to introduce our awesome industry professionals, Stephen Ruotsi and Johanna Monon of Sparring, who will be your lovely, lovely guides walking us through all the legal aspects of running a successful business. Stephen and Johanna, please tell us more about who you are and the background behind Sparring, and take it away.
Okay, thank you. Let me just pop our slideshow up. Great. Yeah, thank you, Michelle and Maya, very much for this opportunity, and all the folks over at Grid 110. We've been excited to do this, and I've attended some of these in the past. I see some familiar faces there. Hello, Craig. Glad that you are here today. And so as just a very preliminary housekeeping matter, nothing here today is legal advice. If you have any particular legal questions, please consult with an attorney. But we're going to try to provide for you a very broad overview of the legal concerns that every startup should be thinking about. So briefly about us, we are a law firm that works almost exclusively with tech startups. We occasionally represent investors as well, but for the most part, we are on the side of the startups. We're headquartered in Bratislava, Slovakia, and we have offices in Slovakia, the Czech Republic, and the US. And Johanna and I are both here in LA. So very excited to be a part of this with Grid 110 today. And our goal as startup attorneys is always to make sure that you're ready for your next round of funding. So with increasing round sizes, you're going to have increased scrutiny over all of your books, over your contracts, all of your relationships with your employees, your independent contractors, your vendors. And the investors are going to have a law firm with 10 people looking over everything with a fine-tooth comb. So we try to get way ahead of that and make sure that we're not scrambling to clean up things when that investment round does come around, that it's just the business terms that are going to need to be negotiated, and you're not going to have to worry about cleaning up something that your attorney should have handled a while ago. So the state of legal affairs in the US. So unfortunately, we hold the top spot in the entire world for the largest number of lawsuits. So we have a ton of businesses and we have a ton of lawsuits. It was estimated in 2020 that US companies spent $22.8 billion on commercial litigation. And the more successful you become, the more a target you're going to be from disgruntled ex-employees, from competitors, maybe from a co-founder who left. So we always want to keep in mind that there's a good chance at some point along your journey, you're going to be sued, and that you want to be as protected in advance as you possibly can. And that means not having loose ends. Have everything as explicitly drawn out in your contracts as possible. So I know that there is a broad spectrum today for where founders are on their journey. I imagine there's some people who, your startup is your side project, you haven't yet incorporated, for example, and there's others who might be on to their Series A rounds. So as this is an overview, we'll hopefully touch on things that apply to everyone. But we wanted to start at the very first day, which is who's running your company. So are you a solo founder? And I don't know if we can do a show of hands with the buttons here, but if you could, and you are a solo founder, let us know. Okay, so of a few of you, yeah. And so anybody else, that means that you must have a co-founder. And ideally, you have a founder's agreement with that co-founder. So I know a lot of people, they think, oh, well, this is my best friend. We're starting a company together. Why do we need to have anything written? And what I always tell people is that you hear the same thing about marriage and prenuptial agreements. And we all, of course, hope that marriages are happy and loving and last forever. That's not always the case, and that is also not always the case with startups. So even though it's your best friend or it's your brother or it's somebody that came super highly recommended, you want to first establish what the relationship's going to be between you and your co-founder. So this founder's agreement is kind of part legal document and also part business plan. So it'll cover what are the responsibilities of one founder, what are the responsibilities of the other, what is the goal of this company, what are we trying to build, and then what is the mechanism if one founder wants to leave, for example. So those are things that we draft up all the time. Sometimes it's a simple 2-page document. Sometimes it's much longer than that. And I do find that a lot of our clients that come to us after they've started running their company, they don't have those founders agreements in place. And it's not always, you know, the end of the world, but you are better protected if you have that in writing when you start off. So sorry, operating this from here. Okay, so after you've got that founders agreement in place, you are going to want to actually start your company. And in doing that, you are likely going to form a corporation, and I will let Johanna take it for a bit now.
Well, thank you, Stephen. I just want to make sure that the slides are not showing. Just in case that's.
Oh, okay. Well, that's
We're gonna have a technology 101 after this.
I appreciate that information. You haven't missed anything. These slides are just guides.
Of course, but yes, thank you. So, I mean, sometimes questions are, one question is why incorporating, and most of you may know, but the main reason why we form or we set up a corporation is to make sure that there is no personal liability for the debt of the company. So that's really the number one reason, making sure that the owners are not liable, and it's the maximum liability would be the assets of the company itself, not the personal assets of the owners of the company. And that's why it's important to have a corporate form. It also looks more serious for investors, of course, but it will save time, because everything that is developed before, any intellectual property, if you have already vendor or third-party agreements, then this will have to be transferred eventually back under the name of the company. So it's easier to have the corporation set up from day one, so that everything being done is under the name of the corporation, so you don't have to transfer anything later on. And so often it's like, why a corporation? And this is one of the questions that we have pretty much every time is, should I do a corporation or should I do a limited liability company? And investors and founders almost always prefer corporations. LLC is preferred for small businesses when you have limited scale up and no rounds of fundraising. For example, real estate is a type of business ventures where LLC may be preferred. And we've seen real estate startups operating as an LLC. But for investors and for founders and mostly tech companies, this is not the desired form. One of the reasons is that, I mean, we're not tax advisor, but basically when you have an LLC, the revenue and the losses of the company are kind of the revenue and losses of the owners, which means that people investing in an LLC will have to, I mean, they're going to have K1s and they have to kind of report taxes based on their own taxes. I mean, basically it commingles a little bit that the tax form of the owner and the tax form of the company. And this is something people don't want to deal with, and they don't want to have to be involved with a tax aspect of the company, which is why corporations acting as a tax blocker is the preferred way. Of course, as most of you know, Delaware is the preferred state of incorporation, and mostly it's due because it's business friendly. They also have legislators and judges that are very sophisticated when it comes to business matters. So it gives this sensation of trustworthiness, and there's a minimum risk of unexpected result from if there's a litigation from a legal perspective. We kind of, there won't be as, I mean, for example, in California, sometimes it's a little bit weird or unexpected decisions. So something like this, you would not have this necessary in Delaware. And so the corporation also, as you may know, it has its own existence, own rights, own obligations, can sue as well. So that's why it's important to set up the corporation, but also to understand that the corporation is separate from its owner to make sure it has its own legal existence. So when you form the corporation, depending how you form it, can be formed on your own. You may use like third-party legal services, such as Zoom is one of them, or other companies. There's a bunch of companies who do that. But once you have filed the document, which is the certificate of incorporation in Delaware, we call it the articles of incorporation in California. Some people might think that's it, and we do find clients and founders who haven't done the steps after that. Like they just received the certified copy that the company has been registered. However, that's not it. There's a little bit more to it to have a due formation of the corporation. And that would entail having bylaws, which are the internal rules of the corporation. It's not filed, it's private document. You also need the organizational action of the incorporator and the first meetings of the board of directors and of the shareholders. This kind of like finalize the formation, the incorporation of the entity, and also it allocates the proper powers to a director, an officer, and so on, so that later on, when documents are being signed, when instruments are being signed and filed, they are done so under the proper authority of the corporation, which is why these documents are very important. Very often also people forget, but stock has to be issued because that's the evidence of ownership for shareholders. Could be certificated. So you have like this old fashioned certificate of stock, can be non-certificated in Delaware. So you have an issuance of stock that is not permitted under California law, but it is in Delaware. And then you, of course, need to get your tax ID number and stockholder agreements if you want to restrict or impose certain restriction on transfer of stock among the shareholders. And if you want to make sure that certain people will be directors, or if you want a type of a voting agreement among the shareholders, that's also a document that is a little bit lengthy, takes time to prepare, but is very useful at the beginning. It's also important to understand some governance and practical consideration for the formation, because whether you start as 1%, 2 or 3%, understanding who does what will make the paperwork clean from the onset. So in a corporation, as you may know, shareholders, they elect the board of directors, and the board of directors nominate the officers. So that's sometimes we see in paperwork something saying like the shareholders are going to vote for the president. Well, that's a no-no, because the shareholder vote for the directors, and the directors will appoint or nominate the officers. And in Delaware, which is very business friendly, you only need one director regardless the amount of shareholders that you have. In California, it's different. If you have one shareholder, then you need at least one director. If you have two shareholders, you need at least two directors. And if you have three or more shareholders, then it's three directors minimum on your board of directors. So that's important, because we have some situation where California corporation, there would be maybe 5 or 10 shareholders. For example, they raise some money from family and friends, issuing them stock. But then there's only one director on the board, which was the founder himself. And that's something that you have to take into consideration. You also need officers to also kind of run the day-to-day business. In Delaware, there's no required officer position. California, you need a president, a treasurer, or a CFO, and a secretary. One person can hold all offices, which is a good thing when we have only one founder, for example, or two. Then you don't need like a third person, or you don't need to worry about this. Also, keep in mind that directors are not deemed employees of the corporation, but officers are. So if you are faced with people from outside of the US who also want to be involved in the management of the company, keep in mind that having them as officers, if they don't have working visas in the US, might be a problem. But as a director or shareholder, that's fine. There is no such requirements. Also, make sure to have once you have your EIN, make sure to have a bank account that is separate for the corporation. You really want to keep everything separate. You don't want to get into an alter ego situation where the existence of the corporation is being questioned, and where the accounts from the owner of the personal account are commingled with the corporation's account. So keep everything separate. Just sometimes I say to clients, imagine the corporation is your neighbor. So basically you want to have everything and every asset and every bank account separate. Also remember that you're working on behalf of the company and not on behalf of yourself. So, and that's especially true for early founders. There is a tough distinction, because in a way, when it's like one person or two person, people tend to think of like the company being themselves. But from a legal standpoint, remember that no matter how much you live and breathe your company, it is a separate entity, and you as a worker exist separately from your company. So keeping this in mind, it's good to have the mechanisms to really not forget corporate governance documents. Also, you have annual elections for the directors, and then so you have annual minutes for a corporation for directors and shareholders. It could be a 1-page, a 2-page document. It's just like, for example, well, the same directors are elected again and the same officers are appointed again. But it's important to have this annual document in place. Even if you just change a few words, you just change the date, you sign, just keep them in your in the records. If one day, I hope that will not be the case, but if one day there's a lawsuit filed by the corporation, and very often when where there are few owners, people have a tendency to claim an alter ego, and the first thing they will look at is whether the corporate formalities have been maintained. So now I will hand it to Stephen to talk about fundraising, which is what people are very interested about, is where is the money and how do we get it?
Thank you, Johanna. And I just want to add, if anybody has questions as we go along, feel free to put them in the chat, and if we can address them immediately, we will. And if not, we will have some time at the end to do questions. Grid 110 also shared with us some of the questions that you had sent in before today's presentation. So we tried to incorporate those as much as possible. So yeah, let's talk about fundraising, which is very closely intertwined with securities law, and we'll try not to get too detailed into that today, but we'll give you a bit of a broad overview. So, of course, when you start your startup, you know that there's going to be a certain amount of shares that you have available. So like Johanna mentioned, you have to kind of create those shares and have them authorized when you form your corporation. And often what you'll do is you'll say, okay, well, I'm the founder. I'm going to keep a certain amount of shares for myself. There's going to be a certain amount that is available for, maybe another founder or two that might be brought on. There's going to be shares set aside for investors. Well, then there's going to be equity for your employees as well. So we often see that set at about 10%, that the employee stock option plan might represent 10% total ownership of the company. And something I always remind founders is that whether you're working for Google or you are working for a startup that's 2 months old and has $20,000 in the books, you're still getting shares in the company and in a corporation. And the idea is exactly the same, that you're going to work, that your employees are going to work in exchange for salary, but also in exchange for ownership of a company. So where your startup is different from Google is that Google is also incentivizing current employees with very high salaries. In the early stages of a startup, we know that that's not the case. So early on, you're going to be giving probably proportionately larger amounts of equity to these very early employees because they're going to be paid under market rate, and you're trying to attract that talent. But so this idea of a share or a security, what is that? So at the most basic level, a security is a financial asset or instrument that has value and can be bought, sold, or traded. So the most common examples of securities are stocks, bonds, options, mutual funds, ETFs. So your stock options qualify as a security under the laws and regulations of the United States. So there is this test called the Howey test that determines whether or not something is a security or not. And so there are 4 factors to determine whether there is an investment contract going on. And so 1 is the investment of money, 2 in a common enterprise, 3 with the expectation of profit, and 4 to be derived from the efforts of others. So if you are an investor putting money into a startup, then 1, you have an investment of money. 2, it is a common enterprise, right? There are people pooling together to be a part of it. 3, with the expectation of profit. Of course, you're investing because you want profit to come out the other side. And 4, derived from the efforts of others. So if you are the investor, you are not working on the day-to-day. You want to put your money in the company and see it grow. So it is a security just like any stock on the stock exchange that you purchase and don't have day-to-day involvement in the actual running of the company. So the basic rule under the U.S. Securities Act is that when a company issues or sells securities, it has to register those securities with the Securities and Exchange Commission unless there is an exemption or exception. Now, this is, generally speaking, a very lengthy and expensive process. So it is unlikely that any startup up until a very massive size and about to IPO would actually be registered with the Securities and Exchange Commission. Now, that doesn't mean, though, that the laws don't apply, right? So you still have to look for these exceptions. And the penalties for violating securities law are huge. You could have rescission or disgorgements, which means you are ordered to return that investment to the investors. So you just did your $20 million round, and 2 years down the road, you find out that you were running afoul of rules and have been ordered to pay back $10 million. Well, you already spent that investing in R&D and paying your payroll and running your company. That is going to be a very bad moment for your company. There's also civil penalties. There can be criminal penalties, and you can also be barred from issuing or selling securities for some amount of time. So you might actually be prohibited from having more funding rounds in the foreseeable future. one of the things that comes up often that I have to advise my clients against is the idea of incentivizing your employees with a kind of a bonus laden equity structure. So the temptation is to say, hey, I'm going to hire you at, we'll just pick some numbers. I'm going to hire you at 50 grand a year, and you are going to get 100,000 shares in the company. However, if you hit certain metrics, then you're going to get 120,000 shares. And if you hit these other metrics, you're actually going to get 150 or 200. You cannot do that. It intuitively, we feel like we want to be able to do that. But once you start doing that, it makes you the broker or dealer of that security. And you as an individual or the corporation do not have the proper licenses to actually do that. So when you're working on bonus structures for your employees, you can be very creative in how you'll incentivize more cash going to them, but you cannot be all that creative in the amount of stock options that they're going to get. So for startups, the securities, of course, are privately issued, right? Your startup isn't listed on the stock exchange. So the very first securities issued or sold are those that go from the corporation to the founders. So those are your founder shares, of course. Then to raise some funds, you'll issue stocks in exchange for an investment amount. As I mentioned, about 10% will go aside for your employees. Yeah, you need to remember that even though you view your startup as this like smaller thing that's going to be huge in 5 years, but it's not there yet, why would anybody ever care about it? The truth is that regulatory enforcement is inconsistent, and you just don't know when it's your day. It's right. It was just tax day a couple of days ago, and you can say, oh, well, the IRS probably won't audit me, so I don't need to do that accurate job of my taxes. Well, if you've picked the wrong day, you can end up getting in a huge amount of trouble, and that's the case. That's the case here. So I'll pass now back to Johanna, and let's just quickly go over these private offerings and these exemptions to not get too much in the details here.
Yes, thank you. Yeah, I'll try to go over them pretty quickly, but as Stephen mentioned, there are some exceptions for private placement exemptions, private offerings exemptions, and one of the most used is actually Regulation D. Regulation D has been used for many years now, and there are two main subsections there. So we have 506B or C, and basically under these exemptions, the issuer, so the corporation, can raise an unlimited amount of money, but there are some restrictions. And basically, knowing ahead before you start advertising or selling or issuing your securities, trying to understand who you will target will kind of define the type of exemption that is most suitable for you. For the 506B, for example, well, there's unlimited, you can sell unlimited amount to an unlimited number of accredited investors, but no, you cannot sell securities to more than 35 non-accredited investors, which accredited investor, they have to meet a certain income or asset threshold, basically, so that to show that they are not only sophisticated, but they can afford, I mean, no one can afford, but if they lose their entire investment, they will not end up on the street, pretty much. And for any non-accredited investor under 506B, they have to show, though, that they are like at least financially sophisticated and that they have sufficient knowledge and experience to evaluate their own investments. Now, under 506B, the company cannot do general solicitation. So no social media posts, no mailing 10,000 potential investors. That's something you're not allowed to do under a 506B for, I mean, many reasons, but basically it's just kind of a way to restrict and to limit it and to really make it like a private offering. not recently, but within the last years, under Rule 506C of the Regulation D, permits the issuer to actually do general solicitation and advertisement of their offering. However, this exemption is limited to accredited investors, and the issuer has to take reasonable steps to verify the accredited investor status, meaning that under 506B, you would have an accredited investor questionnaire ready. You can find them easily online. You have a bunch of templates on that. And then they would just sign saying that they make $500,000 a year in salary, so they would qualify, or they have $2 million in assets, so they would qualify. Under 506C, you actually have to verify whether that is true. So you would request a little bit more documents from the investors to show that they either they make the income sufficient for accreditation, or that they have the assets sufficient for accreditation. Under both of these exemptions, so 506B or C, the one thing to remember is disclosure of risk is everything about securities. Basically, securities laws are meant to protect investor, and that means that the investors should know the risk and in their investment, and making the investment knowing this risk, meaning that they're accepting them. And to do this, we used to do like PPMs, which are private placement memorandum, very lengthy document, pretty expensive to set up, but that would give an in-depth explanation and disclosure of the risk of the team, who are the personnel, who is running the business, do we have any affiliated, something also inside about the industry, and all these details. Now attorneys have found a way to shorten this procedure a little bit, and instead of having a PPM, we would have like a risk factor disclosure, which is still like a 10-15 page document, but where you lay down all the risk associated with that investment. That way, when an investor reads that, and you want to make sure that they read the document, but when they read this document and they go ahead and invest in your company, then later on, they will not be able to say like, oh, I didn't know that a token offer, like this token was risky. Like, oh, I didn't know that crypto was, like the regulatory landscape of crypto was unsettled, and now there's a problem or there's a risk of exposure on this. Basically, just you want to lay down the risk to make sure they don't come up later on with this type of arguments. Another exemption that has been pretty popular and I think is cool is a crowdfunding. So under regulation crowdfunding, it's basically you would use the services of a broker dealer. Most often it's going to be a funding portal that is registered with the SEC. And the maximum amount that you can raise is $5 million during a 12-month period. And there's a limit, there are some limit on the amount that individuals who are not accredited can invest. But there are also some disclosure requirements. So again, about disclosure, but very often the funding portal will help you to set up this disclosure, these disclosure documents. There's limited solicitation and advertising. So you can solicit, or you can advertise the fact, like the funding portal itself, or the fact that your offering is listed on this portal. One of the good things about crowdfunding, it gives a good exposure, and it gives those portals have a lot of tractions. So you would have people who are looking for this type of investment. They just go on the funding portal, they scroll down to see the available offerings, and it has been very it's an attractive way to kind of advertise or make sure people know that there's an offering going on. Also, we have seen, because you can do a crowdfunding offering concurrent with a Reg D offering. One is not exclusive of the other. So you can, some startups found themselves where the crowdfunding gave them exposure so that potential investors learned about it, knew about it. And then they contacted the issuer to get another type of stock, because for crowdfunding, it's going to be your common stock. But for example, they want to have preferred stock with a preferred rate of return, or to give them more like voting rights or something like this. And so startups would find themselves where they have actually a lot more investment coming on the side, not through the crowdfunding, but because potential investors learn about their companies on the crowdfunding platform, which is why it's I think it's pretty cool. And it's when it's a successful campaign, it can bring a lot of traction and fresh investors for an extended period of time, and not just limited to the crowdfunding itself.
Yeah, we had a couple questions come in from Alex Kim. Thank you. So how does one define reasonable, and how do you verify sophisticated investor? So as Johanna mentioned, there are these accredited investor questionnaires, and that's the best thing you can do to protect yourself there, is to make sure that the investors fill out those questionnaires. So those are going to make sure that they check all of the boxes that would make them qualify to be accredited and or sophisticated. So you know, looking at their net worth, their salary, and whether or not their job is something that involves finance. You know, so they might not make as much money, but they work in finance, so the government assumes that they are sophisticated in looking at these types of matters. But those questionnaires, even when you're doing a SAFE, which we're going to get to next, it's always good to have your investors fill those out, because it's one thing if you talk to them on the phone and they tell you, oh yeah, I have $3 million in the bank, I make a bunch of money every year, I'm accredited. That's great, but you need it on paper. You know, back to the original theme here of making sure that down the road you're not scrambling to put documents together or to prove things. You want to have that filed along, you know, in your data room along with those investments, and saying, oh yeah, Alex Kim invested in our company, and here is the investor questionnaire that shows that this was a valid accredited investor.
Right,
yeah,
and to just jump on what is reasonable, well, asking their all tax returns for the past 5 years might be unreasonable. But asking them, for example, a document showing the balance statement on their bank account, that seems pretty reasonable. I mean, if they want to redact some, like their address or like whatever, other sensitive, but something sufficient to show that the person actually has what they say they have. If it's going to be, for example, based on income, then maybe have like a payroll stubs or something like that. So just doesn't have to be in depth, but it has to be something that shows that they're meeting the thresholds.
Yeah, and this next question, angel investors, it's a fancy term. It's a pretty word to describe an investor, but all it really means is it's someone who's coming in early, not taking a lot of involvement with your company and putting money in. So they need to be accredited just like everyone else, but they are generally, it's not going to be their first investment, and they are very sophisticated and they are accredited, and this is something that they do all the time. So a lot of you in the early stages will be looking at convertible notes and safes. So I want to just quickly talk about the history of safes. So Y Combinator, the accelerator program, decided maybe 10 years ago, I want to say, that there was too much time lost and money spent squabbling over terms for early investments. And the idea is that if you're a startup trying to get your first $100K, $500K, $1 million in, that should be able to happen pretty seamlessly and without needing a bunch of bickering between attorneys. And you know, Johanna and I could tell you all day about the intense redlining we get from attorneys on other sides of deals. So the SAFE is meant to eliminate that from happening. So I always say, if you send a SAFE to an investor and you've agreed, hey, you're going to give me $100,000 and you're going to have a 90% discount rate, so you're going to get a 10% off at the next round. If what you then get back is a heavily marked up agreement, then you should think twice about that investor, because that shows that they don't understand the purpose of the SAFE. and that they might not really have the best interests of your startup in mind. So all that really is negotiated on there is how much are they investing, and will they be investing based on a valuation cap, a discount rate, or both? And is there going to be what's called a most favored nation clause, which basically means that investor is offered any follow-on investment at the best terms any other investor is going to get. And that's generally something that's really important to investors at every stage. They want to know, hey, I'm investing now and I'm getting 8% of your company. I want to have the opportunity at the next round to keep my ownership. So I'm going to get my pro rata rights. So safes, I'm a big fan of them, because the time from negotiating, getting the questionnaire filled out, drafting the agreement itself takes 5 minutes if you know the terms. They have it signed, and then they send that money over to your corporate bank account. So it is absolutely the quickest way. So once you've formed your company and you've started issuing equity, even if it's just to yourself, you always want to be thinking, what does my cap table look like? So there are, of course, softwares out there, Carta being the most popular one right now, but you always want to keep that cap table updated. So first question is, who is on it? Do I have every investor and every employee who's on the stock option plan accounted for, right? You should never have a situation where you say, oh, well, okay, I hired somebody 3 months ago, I promised them equity, but it's not tracked anywhere, right? It should always be tracked somewhere. And same with, oh, well, we got 9 different safe agreements, we're going to worry about it later. Don't worry about it later. The cap table is going to be one of the most heavily scrutinized part of your data room when you go to raise a round. And so make sure that it makes sense. Make sure that the numbers add up. And one of the reasons I do suggest using a software is, if you don't use a software, you end up trying to write codes in your Google Sheets or your Excel. And I'm sure some of you are very well qualified to do that, but these softwares are designed to do this every day. That being said, Johanna and I did have a situation a few weeks ago where a client's cap table management software fed them a wrong amount of shares for an employee that we were helping them terminate. So always be critical when you look at those. What's the cap software you'd recommend? So what I've been enjoying lately is a company called Cake Equity, and they're actually around LA and Orange County a bit. They were founded in Australia. It's an Australian founder, but I met them at a meetup in Manhattan Beach a while ago, and they have a very strong platform. So I think that's worth looking at. Okay, and then yes, for the rest of this presentation, I just want to quickly run through some things that you should be thinking about, and then I will hopefully leave these last 10 minutes for free questions. So firstly, IP, right? Every startup has IP. That is often where early on all of your value is. So until you start actually having revenue and having profit, it's your idea that has value. So the name of your company, make sure you trademark that right away. Make sure you have not only the URL for your company, but try to buy closely related URLs. Look to see, are there other companies with similar or the same names? That's not necessarily a problem as long as you are in very different industries, but you want to be careful to not put that off for a while, right? So you want to immediately Google search, look far and wide for that. So you'll trademark your name, trademark any logos. Now, patents are a much more lengthy and expensive process, but if you do have some type of technology that you want to patent, you should begin speaking with patent attorneys and working on that. We have a question come in: stacking or other relations between multiple entities with different but related IP. All right, so I don't fully understand John's question there, but what I would say is you're always going to end up licensing someone else's IP at some point along the way, but anything that you want to be part of your company's suite of IP, make sure that your corporation itself owns that IP. So when you're hiring somebody, for example, a developer, you want to make sure that they're not bound by any previous agreement that's going to have their IP transfer back to their last employer. Similarly, make sure you're using NDAs whenever you're talking to to different vendors about your product. Investors generally aren't going to sign an NDA, so they'll think it's kind of silly if you bring that. But if you're talking with somebody really in the industry who you're concerned might benefit from your idea, make sure you have the non-disclosure agreement signed. So next, laws and regulations. A basic point here is that laws are passed by Congress and regulations are then created by agencies to implement those laws. So the Security and Exchange Commission, for example, they are the SEC itself is created by statute. There are many laws, but then the particular regulations that they implement are what you need to adhere to. And so if you yourself are running a startup in a highly regulated space, such as medtech or telecoms, for example, you're going to need to make sure that you are following FDA or FCC regs. Similarly, if you're doing anything to process user data, make sure that you are following the CCPA, our Privacy Act here in California, or if you're in Europe, the GDPR. There's also going to be local laws and regulations related to employment and minimum wage. You always want to check with a local attorney or maybe the HR provider if you have one regarding what particular things you need to know about employing in that state. Good to note that you also should be at least paying yourself minimum wage. So even if you're the founder and you think, well, no, I'm not taking a salary, that can actually violate the law. So on the books, you should be paying yourself at least the minimum wage in that state. And then broadly speaking, you need to be vigilant and looking for disputes. So if there is a disgruntled employee that you've fired who didn't sign a severance agreement, you might have litigation pending down the road. If you have an agreement with a vendor and they keep claiming that you did not deliver on your side of a contract, they might sue you for breach of that contract. Similarly, if a vendor owes you or a customer owes you $100,000 and they're just refusing to pay you, you might have to sue them. And so those are things that when you get to that next funding round, the investors are always going to say, hey, are there any disputes on the horizon that could lead to litigation? Because litigation is extremely expensive and no investor wants their money to be going towards litigation because then it's not going towards building the company. So with that, okay, I'll go back to these questions. So Stacy asking about data privacy, legally collect, store, and sell data. Is that in terms and conditions? Okay, so there's a lot of questions there. And there's no such thing as removing, liability. You're always going to have to be careful to make sure that you are acting in accordance with the law. Because if you violate the law, even if you have a clause in a contract that limits your liability, generally, if you have engaged in some sort of gross negligence or bad act under the law, that's not going to protect you. But what I always say for terms and conditions and data privacy is to try to find well, firstly, have your attorneys do it, but absent that, find whatever company looks most similar to yours that is much larger. So if you are a mental health app of some kind, go to Headspace's website and look at their terms and conditions in their privacy policy. Read through there, and it's very likely that 95% of what's there is going to apply to what you're building as well. So you can go in, look at that policy, say, yep, this matches almost exactly with what we're doing. You copy and paste it into a Google Doc and put your company name in. I would always recommend that you work with an attorney on your data privacy and on your terms and conditions, even if you draft them yourself, just to have them reviewed before they go live on your website. John, you can feel free to get in touch with us directly if you'd like to talk more. Personal data on background check results if I need only a pass-fail result for legal reasons. Barbara, that seems like a pretty particular question, so I don't know exactly in what situation the pass-fail only would come into play.
And maybe too, because I feel I have an idea of what John is asking here based on what it says, but when is it better to keep the IP in one company and running another one? So, I mean, there's, again, whatever asset you have in your corporation that is raising fund and having investors, you're exposing the assets to potential liability. So to the extent that's not something the company wants to do, then one way is to actually stock the IP into one company and have like a license agreement, which between the company that owns the IP and the company that is raising fund, for example. And then you would have a license agreement that in a way is also valuable in itself. Now, if you have investors who are willing to invest in a company that does not directly own the IP, that's another question. That's more of a business term or a business negotiation there. But that would be one reason why it's better to have, maybe I see your point. Why it's, if there's a risk of losing the IP or exposing it to liability, then having it under another entity would help. Also, I think there's a tax reason, but that's beyond the scope of this presentation. But yeah, I don't know if John, that answers your question.
And yeah, and we have had situations where people have individually created their IP before they formed the company, and they want to license it to the corporation rather than having the corporation own it. But those are all unique situations that you deal with, and there's not a blanket way to best deal with that. Sam asked, can you touch upon co-founder equity and percentage of shares between co-founders? So yeah, I mean that's one of those negotiating points that comes up early on. And I had one situation about a year ago where I was working with two co-founders, and at first they agreed that they would be 50-50. And then the one co-founder said, well, I'm the one who's putting some initial money into this company, so I should have a higher percentage. And that conversation ended up leading, unfortunately, to the company not getting off the ground because they just couldn't agree on that. And when I talked to the co-founder who is going to have less than 50% in this scenario, who was the one who had brought the project to me, I said, I know this feels terrible that the startup is not going to be formed in the way that you thought, but if you were going to have that issue with your co-founder right now, who knows what kind of issues you would have had down the road, and it's way better to get that sorted out right away. But I would say that if you have a co-founder and you really believe that that the two of you are going to be running this company together, it's going to be mud, sweat, and tears, then it's a great thing to have your company split 50-50. I mean, that's a really as long as it aligns your incentives. But if you look at it and you say, realistically, I'm going to be the CEO, I'm going to be running this company, and my co-founder is like technically very talented, but is going to be doing less than me, then maybe it's 60-40 or 70-30. Val asked regarding operating agreements for working remote across multiple states. So yeah, we all live in a remote work economy right now, and you always need to be complying with the local laws of, excuse me, the state where your employee pays their taxes. It's really hard to even just say, oh, it's the state where your employee lives, because they might be moving around, but wherever they pay their taxes is where the employment laws are going to apply. So if there are certain restrictions for example, if you're hiring somebody in New York City, there are not only New York state laws, there are New York City specific laws. We've seen more laws passed recently across states and cities regarding publishing salary bands. So if you think you might hire somebody in Colorado, you need to specify a salary band for those people. So you always, if you can, the best thing to do is to check with a local employment counsel in that state, but be very clear with your hire up front with where they pay taxes and where the state they are working in actually is.
And I think Val asked a question about allocating certain money amount raised. The document, the disclosure document I had mentioned, so whether it's a private placement memorandum or another form, there's always a disclosure of how the funds will be used and where they will be used. So is it to pay salaries of the officers? If it's for research, is it to advertise or actual production, anything? You have to disclose to your potential investors where the money is going to be spent. So if you want to spend it on something else, so to go to a fund, that will have to be disclosed, because the potential investors need to know where the money is going, pretty much. So if you want to allocate 5% to that, then you have to write it down to make sure that they know that 5% is going to that grants for the community, as you mentioned. Just because I feel like, John, we haven't really answered the other question, but if a film company has a company for an individual film and one for funding, you're going to have to link both at some point. No investor is going to invest just without a link for a return of money. So if, for example, it's a return of money from the other company that owns the film, you need to link either a revenue share, a percentage of profit, or something like this. It's not that attractive in a way because there's just a barrier, but from a business and to attract potential investors, the two entities would have to be linked somewhere so that there's a return of money somewhere for the investors.
And yeah, we are just about at the end of time here. So, oh, I didn't realize we were still sharing our slides. So there's our emails. Please feel free to get in touch with us or to contact Maya or Al, who can also relay you to us, but feel free to email us directly. Of course, if you have any other quick follow-up questions that you want to cover, we're happy to discuss those. And Al and Maya, thank you very much for this opportunity. As I mentioned, we are here in LA. We're an international firm, but Johanna and I are both here in LA and are really appreciative of the opportunity to be part of the Grid 110 community, and are looking forward to being more involved in the coming months and years.
Thank you very much. Thank you.
Thank you guys so much. Questions. Thank you everyone for attending our event. You will get an email shortly with the link to this presentation. If you have any additional questions, please feel free to reach out to Stephen and Johanna, who has kindly offered up their emails. And I think one of the things as a community that we get to do is to connect to wonderful humans who can give us insight. So if you feel like your questions weren't answered, or if anything, just please feel free to reach out to them. And again, thank you guys so much for coming through. I have added our socials if you wanted to keep up and follow along for more content. And again, thank you again, Stephen and Johanna, for this awesome presentation. Have a wonderful day, y'all.
Have a great rest of the afternoon.